May I have a question to your presentation? Who is the plaintiff in the two cases you had just said?
In the first case, for the federal court judgment, it is the individuals who were the partners of faith enterprise that own the logging rights. So in that case, the individuals sold their logging rights to Centennial. So when they didn't get their balance 2.5 million, the individuals who were the partners of faith sued directors for fraudulent trading. In the second case, the plaintiff was the legal firm where the company owed them 5 million ringgit legal fees.
That means the law firm is one of the creditor.
Yes,
creditors
correct.
Of the company.
Yes.
Yeah. Yes, I understand. I see. Today I am glad to share some difference in the law of Vietnam, in corporate law. That is the law on enterprise 2020. In Vietnam, under law of Vietnam, there's two kinds of the lawsuits: ordinary lawsuit and derivative lawsuit. I divide into two cases. But firstly, I would like to explain some things about the transaction may raising the personal liability of the director. The first is the transaction between company and the related parties without approval of members of the or the general meeting or the share of the shareholders or the board directors. Under the law of Vietnam, the transaction can be invalidated according to the court decision and handled with consent law. And second is other transaction violating the personal responsibilities of the manager and harmful to the company, raising the personal liability of the director. Next slide. Yeah. The two kinds of lawsuits I would like to share today. First is ordinary lawsuits between company and the director when the director violated his or her responsibilities. But in this case, the director is not the legal representative of the company, and the legal representative of the company who signed the petition to sue the director. And the second lawsuit is the ordinary lawsuit between company and the director. It's wrong. No, it's derivative. It's wrong. It's wrong here. Derivative lawsuit. It's wrong. Derivative derivative lawsuit between the company and the director, which is applied when the director is also the legal representative of the company or the legal representative does not want to sue the director. And the company never sue the director because the director is also the legal representative. He doesn't want, never want to sue himself. No, or legal representative does not want to sue the director. And when and then the member shareholder owning at least 1% ordinary shares, a group of them has the right to initiate a lawsuit against the director. We call it derivative lawsuit. In Vietnam, we don't have the work to express this case. And then member and the shareholder will sign petition on behalf of self or on behalf of the company to protect the interest of the company or others. Yeah. The law on enterprise Vietnam gives the right to the member or shareholder to initiate a lawsuit against the director. That means the member or shareholder have the right to sign the petition on behalf of himself on behalf of the company. Yeah. This is my comment. You know, one of the basic civil procedure rules is that only the subject suffer damage has the right to initiate a lawsuit against someone. But in the derivative lawsuit, the member and the shareholder who and not the suffer damage, hit the right initiates the right against the director. The director is a person
Yes.
who make the damage,
Thank you.
cause the damage to the company.
Yeah.
That is the exception. In an exception of the proper anti rule, one the basic civil procedure rule.
Thank you very much. Just thank you very much, Siew. Thank you very much. Now for the Q&A, I would like to ask the audience to ask any questions in relation to that. I found the presentation of Siew was very, very interesting because I think Malaysia also had a derivative action, but we don't have fraudulent trading. We don't have wrongful trading. Not as much as we have here in Malaysia. Now, correct me if I'm wrong. We have one provision mentioning that if the parent company interfere with the action of subsidiaries causing the damages to the subsidiary, then the shareholders of the subsidiary has the right to sue the parent company for that. I don't know whether it's called wrongful trading or fraudulent trading.
No,
Not really.
that will not fall under
That's
that
different.
category.
That's different. So we don't have wrongful or fraudulent trading in Vietnam, and I think that's something we need to learn from Malaysia for that purpose. And also the differences between wrongful and fraudulent trading. At the time too short, I cannot grab the differences, but I think it's very, very interesting. I think in Vietnam we make big fuss about what is the chattel capital of the company, and they control the chattel capital of the company very strictly. Whereas in smaller country, you can have $1 company, $2 company, no problem. Nobody cares, right? And there's a limit liability of those companies, and we misunderstood in Vietnam. We misunderstood that the liability of the company is the charter capital of the company, which is wrong. The charter capital of the company is only the liability of the shareholders, not the liability of the company. So who cares if the company have a legal capital as $1? It's important. It can own a $1 billion facility. It can borrow money and can have the $1 billion borrowing, and they can have the facilities with borrowing. That is only trigger. The shareholders only trigger when there is a fraudulent or there is a wrongful trading. And they make a $1 billion borrowing without intentionally knowing that they don't have that money. And that is the situation where wrongful trading or fraudulent trading comes. I think just to show how far we are behind common country in terms of company law. I think we even changed the company law many times, just focusing on charter capital, which is irrelevant in many countries. And that's alone, I think, is worth to learn. Perhaps we should have a different view on this. But just my comment in relation. And thank you very much for your presentation. And I think that is also a warning for the company to set up outside. They can do transaction, they can do project finance, but they have to prove the capacity of performing the contract. Otherwise, the shareholder would be responsible for wrongful or fraudulent trading. Yes. So, other questions? Yeah. Okay. Ha, you want to have questions?
Good evening, Ms. Siew. I deeply focus on your presentation. Thank you so much. I have two questions concerning the doctrine lifting the corporate veil, if I correctly understand. Yeah. So if I correctly remember your presentation, I have the first question that whether the doctrine lifting the corporate veil apply only for limited liability company, or whether it apply for other form of the company, for example, like partnership or joint stock company. So and the second question is that if I correctly understand the doctrine, it says that the director who acts under the name of the company, but wholly for his own benefit. So the doctrine would apply in this circumstance, right?
Okay, maybe I'll take the second question first. Your question, if I may repeat, is that whether the doctrine applies if the director acted for his own benefit. Is that right?
Yes, under the name of the company.
Right. Okay, I think that one will not fall under fraudulent trading or wrongful trading. It also does not require the piercing, because your common law duties and also statutory duties for the directors is to act in the ultimate interest of the company. So those are actually codified in written law. And if you violate that and the company suffers damage, the company being proper plaintiff who has suffered can then sue the director for the breach of those duties. So that's quite separate from piercing the corporate veil. Yeah? Okay. So the second question is whether this doctrine only applies to limited liability companies or whether it applies to other forms such as partnership. Now, in Malaysian law, which would be similar to Singapore and UK, Australia, is that when it is a partnership, it is a personal liability that is, well, basically the partnership may have a name, but that's just out of convenience. So you may have 10 partners and it goes by the name of, well, it's not ABC, okay, by the name of ABC. So it's trading as ABC. But the law will look at it as each and every one of the 10 partners are actually trading, not the company. So it does not take a form of a separate legal person. So from day one, there's no veil. So there's also no issue of piercing corporate veil. So to answer the question, it only applies to limited liabilities where there is a veil, where the law treats that particular entity as a separate legal entity. Although it's a fiction, but as far as the law is concerned, it's another person.
So to give you an example, if the company buy a car, but I use it like 100% of the time, and if the company goes bust, a car still under the loan, should the owner of the company be responsible for that?
No, but
Okay.
I think it's more a tax issue.
Okay, yes.
Because as to whether you were utilizing it for the benefit of the company or actually a personal use.
Yes, so it's nothing to do with the fraud
No.
or the wrongful trading. Yeah, thank you. So
I have,
Hi, Bob.
I have one question for both Milfu and Ms. Siew.
Yep.
About the wrongful trading. Like under licensing law, you say that let's say the director may, if they have the wrongful trading, and they that they have liability, right? And under the law of Vietnam, also if the director say he did the wrong thing and not for the benefit of the company, then he still be liable for that. So my question is, if the director said that his decision at the time he made a decision, he believed that the decision he made is the best thing, the best choice, and he cannot forecast in the future, maybe in the next month or next year, everything changed and the decision is no longer right. And at the time, can you sue him as a wrongful trading or not for benefit of the company? Yeah, that's the question.
Thank you. I think that is very fact-based. So in an adversarial system, the lawyers are free to demonstrate their creativity in court, of course, within the limits of the truth. So if you can demonstrate or prove to the court that in your honest belief, and it's not just a question of what you believe, it must also be supported by facts. So for example, what is the health of your accounts at that point in time? Now, if you are saying that when you contract at that point in time, you freeze it and say you are being wishful that I can collect on this amount, that may not be good enough for you to avoid a wrongful trading offense. So it's very factual. It really depends on the kind of proof that you can demonstrate in court. And it's not just about what you thought at point in time, it's the surrounding circumstances. So it's a subjective and an objective test.
Yeah. I think the question of I think is very important here is that when foreigners come to Vietnam and they sign the contract, they have two things. Number one, they have a joint venture contract or shareholder agreement, and then you have charter, and the charter is governed by Vietnam law. So you have derivative action, you have the action against the parent company, and so on and so forth. On the other hand, the joint venture agreement can be governed by English law, and would that situation it comes into play the issue of fraud trading or wrongful trading between the shareholders and the company? Because let's say you and I have a joint venture, and we have an agreement that you hold the general director, I hold the chairman. And but then soon after, you and I have a different views, different vision. I have a short-term vision. I have make money now. You have a long-term vision. You say, I don't care about the money now as long as 10 years later we have a bigger trading and so on and so forth. And as a matter of fact, the company under your CEO making losses. I cannot sustain. I say, okay, you deluding me because now you ask for increasing the share capital and so on and so forth. I don't see any profit. And maybe I think that you are acting like wrongful trading or fraudulent trading, and I sue you. Would that be a risk? Because under Vietnam's law, it's not possible. Right. But under English law, that might be the case.
Yes. So it goes back to limited liability entity.
Right.
The law that's applicable for that limited liability entity would normally be where it's incorporated.
Right.
So regardless of you having a joint venture agreement
Yep.
elsewhere in Vietnam, Thailand, wherever it is,
Yep.
it goes back to where is place of incorporation of your company.
Yep.
So if you have that company incorporated in Malaysia, then
Yep.
it triggers automatically.
Okay.
Yes.
Yeah. So that could be the situation of people considering that if the motivation is to kick the other parties out, then could be wrongful trading or
Yes.
fraudulent trading.
More bullets.
Yes. Thank you. Thank you very much. Thank you very much. So I think that is the end of the
Thank you.
Thank you very much, Nguyen, and thank you very much, Just Fu. I think we will have